Good morning. My name is Dan Valdivia, and I'm a licensed realtor in the state of Florida for 14 years. This morning I'm with Gentle Barnett.
Good morning, Daniel.
Good morning. He's a licensed attorney in the state of Florida for 15 years, correct, Gentle?
That is correct, yes.
Good. Well, there is a question, Gentle, that I get from buyers and sellers, especially regarding an attorney. I understand that some states don't require an attorney. So should they use an attorney even though it's not required?
Yes, because first thing, many times clients shop on price.
Mm-hmm.
The services that an attorney charges, most times it's the same as what the title company is going to charge.
That's important.
Second, it's better to have an attorney in the transaction because many times when you're selling a property and you're purchasing a property, you need to make sure that you adhere to the timelines. Making sure that they submit their loan application. Second, making sure that if they're purchasing, that they have their escrow deposit, or the buyer who's purchasing their unit, that make sure that they have their escrow deposit in place. And second, that they put their escrow deposit with their new purchase.
Right, I see.
So therefore, you need to make sure that there's two timelines going on in the transaction, one for the purchase and one for the sale.
Right, right. Gentle, a lot of clients of mine think that a real estate transaction is kind of a simple process, yet sometimes bad things happen.
That's correct.
Can you share some stories that you might probably have?
Many times clients would go with a title company and to represent them in the transaction, but they have had instances or horror stories where the title company would forget to have the seller close out on a line of credit. A line of credit is almost like a checkbook.
Right.
So if that account is not closed, it may be a zero, but if it's not officially have an authorization signed by that seller to close that account, that client, that seller can now charge up that line of credit again. And we had an instance where we had a client who was doing a purchase in our property, for a deal. However, they had to wait almost 2 years until litigation, went through in order to make sure that, because that previous owner charged charge up that line of credit
After closing.
after closing.
Oh, so now they're charging on an account that it has that is backed by the home that
Right.
they do not longer own.
That's correct.
My God.
And
Talk about that.
And obviously, attorneys had to get involved. There was a lawsuit because that client, that's previous owner, failed to start paying on that account. So then, therefore, it went into foreclosure. And how it works in Florida is that it's first priority, whatever is recorded first.
Right.
So since that line of credit was recorded first, they're now in first position, so they could sue everyone, the entire transaction, anyone afterwards.
So you definitely need an attorney, bottom
you
line.
do.
Just avoid
Definitely.
any pitfall
Correct.
that might come up, right?
Correct.
Good. Thank you, Gentle.
Thank you,
And
Daniel.
in case you have additional questions, please contact us on the phone numbers listed below.